Good afternoon, everyone. It is now 2:30 p.m. and we are live. Thank you all for joining us for today's presentation. My name is Jaleesa with Legal Aid of North Carolina's Helpline. Today we have Carly Odell presenting for us. If you are unfamiliar with the format of this event, Carly is going to review a PowerPoint presentation. At the end of the presentation, we'll have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during that Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Carly will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Carly to get us started.
Thank you so much. Welcome everybody to today's Listen and Learn provided by Legal Aid of North Carolina. My name is Carly Odell. I am a staff attorney in the Durham office of Legal Aid. Today we are going over child custody. So if you're here, this will be for if you're thinking about filing for custody, and really we're going over the custody filing process. So if you are about to start that filing process, this would be the Listen and Learn for you. If you have already filed for custody, or if there is a custody order already in place, this is not the Listen and Learn that would be helpful, but we may go over a little bit about modification in part of this presentation. With that, Legal Aid of North Carolina is a statewide nonprofit law firm that provides free legal services in civil matters to low-income people in order to ensure equal access to justice and removing legal barriers to economic opportunity. We have different practice areas, which include housing, employment, education, domestic violence, disaster relief, and consumer. As I said, today's Listen and Learn will be going over child custody, but we do have monthly Listen and Learns for a variety of other topics, including divorce, simple divorce specifically, criminal record expunction, tenant rights, Social Security disability, Medicaid rights, SNAP 101 or emergency SNAP, which is food stamps, Medicaid eligibility, and healthcare power of attorney and living wills. If you want more information for those Listen and Learns or to register for any of those, you can go ahead and go to our website and visit the Listen and Learn page. All right, as stated, today's Listen and Learn is going over child custody. And as stated before, Legal Aid does not represent you. This is just an informational session, and we will be answering general questions. But as stated before, we cannot answer specific questions on your case. The intent of this Listen and Learn is for pro se representation, which pro se just means you're representing yourself and there's not an attorney involved, for initial filing for custody and or visitation, and we are applying North Carolina law only. So this Listen and Learn will provide assistance in initiating a custody action, as I stated before. And again, as stated before, if you have already filed a custody case or there is a custody order in place, which does not include a temporary custody order that would come out of a domestic violence protective order, that's something different, you would need to file a motion to modify, and we can provide information on motions to modify upon request. I will touch on them a little bit later on in this presentation. So about the law, the North Carolina law is divided into chapters, and for the purposes of child custody, we're going to be looking at Chapter 50. So this specific chapter that we're looking at is the North Carolina General Statute 50A and 50-13.1. 50A talks about child custody specifically, and then 50-13.1 talks about custody and mediation. So when we're thinking about custody and the law, the standard for parents is best interests of the child. When you file a custody action, the determining factor of what will come out of that custody action is what is in the best interests of the child. If you are a non-parent, the standard involves unfit parents because the parents do have to be determined to be unfit in order for them to no longer have custody and for a non-parent to be able to get custody. Some terminology and definitions that will be important for this listen and learn will be plaintiff and defendant. So the plaintiff is going to be the person that files the action. So if you are the person that is filing the action, you would be the plaintiff. The defendant is the person that the plaintiff is filing against. So we might think of it with a negative connotation when we hear defendant with criminal, but for custody cases, it's just the other party. It's not a bad thing if you're the defendant in the case. It's just that the plaintiff was the one that filed it and they get to present their case first. Pro se, like I said before, means you do not have an attorney and you are representing yourself. Primary custody is the person that the child primarily lives with. So this person would have more physical custody, more time with the child staying with them than the other parent. Visitation then is what the other parent who doesn't have primary custody would get, and that is visitation with the minor children for however long of a period that may be. Legal custody is different from physical custody because legal custody is the power and ability to make decisions about the children. So deciding on, religion, schooling, those sorts of things, medical decisions, that is what legal custody is. Physical custody is the right to have the child physically with you. More about the law, who can sue, so who can file a custody action. This would be any parents, but other people can file as well. This would include relatives, other people, agencies, organizations, or institutions who claim a right to custody or someone with a relationship to or with the child. So the Department of Social Services, Child Protective Services are an example of an agency or organization. And then, for example, grandparents would be another relative aside from the parents that could potentially file a custody action. When you go to file, you want to file in the district court in one of two places, either the county that you yourself reside in, or the county where the child and the other party reside if it's different than the county where you live. Either one is fine. And what would make the most sense is if the child goes to school in either county, it might be more beneficial to file in that county. And when you should file, anytime after separation. And this doesn't mean that you have to have been married before. It's just when the two of you, the two parents, are no longer together and no longer living together. That is when you can file a custody action. However, children do have to be a resident of North Carolina for at least 6 months prior for the court to have jurisdiction. So if you've just moved here, you'll have to wait 6 months. Or if your child is younger than 6 months, they would have had to live the majority of their life in North Carolina. For parental rights, until a written court order exists, both parents will have equal rights to a child. Law enforcement will not help anyone retrieve children if there is not a court order in place. So if you have an informal agreement with your ex-partner, the other parent of your child, you cannot call the police to help get the child back from that person unless there is a court order that tells them to do so. Further, if your parental rights have been terminated, you no longer have the right to sue, to file a custody claim. So if you are in that position where your rights have been terminated, there is another route that you have to take to get those back first before you can initiate any custody action. Additionally, child support and child custody can be litigated separately. They are not the same claim. You would have to file 2 different actions for each individual action. And if you are awarded child custody, that doesn't automatically award you child support. If you are awarded child support, that doesn't automatically award you child custody. They can be litigated together, but they are separate actions. There are a few different things that you could be seeking from filing custody. So there is joint custody, which is when both parents are sharing the custody, they're sharing physical and legal custody. So both will make the major decisions. And typically the child will primarily reside with the one parent, the person who has primary custody, and the child will have visitation with the other parent. Exclusive or sole custody is when one parent has custody, legal custody, making the major decisions, and the child will primarily live with them, but other parents often do have some kind of contact or visitation. But for sole custody, that means legal custody is with one parent and primary physical custody is with that same parent. Now, visitation is the non-custodial parent's right to see the children. The amount, how many days, how many weeks, and the type determined on the ages of the children, how close parents live to each other, and it's typically on a schedule. So if you don't have the primary physical custody, you would be receiving visitation. So you could be seeking either thing when you file, either custody or visitation. Before you file, you should really take into consideration different aspects of your life and if it is the best time for you to file. Like I said, child support is a separate action. So you are not required to file child custody in order to file a child support claim. You could file your child support claim at any point. You also don't need a custody order or a custody action to apply for any welfare assistance, to enroll your children in school, any medical insurance, or temporary child care. It is not required that you have a custody order for any of these things to be filed. There are certain drawbacks to filing, which is why we say consider your circumstances and consider everything about this before you make the decision to file, because these cases can be very time consuming. You have to often take numerous trips to court between the different hearings and mediation. The courts will be examining your personal life, and that is including your employment, the history, what you're doing now for work, your mental health in the past and presently, whether or not you have a criminal record. They're going to look at your character. They're going to look at whether or not you have a significant other, and they'll look at their character as well. And this is not an exhaustive list. Anything that could be considered important to the best interest of the child's life is going to be considered when the court is making their decision. This also, another drawback to filing is sometimes parents that aren't interested before all of a sudden will be invested. So before, they never really took the time to spend with the children or did anything with the children, but after filing, they all of a sudden want tons of visitation, tons of overnights, and so it might change things a little bit. The court may also make disagreeable orders. They may order something that you do not like, such as giving the other parent more visitation time than you would prefer. So these are all things that you would want to consider before you file, and understanding that it may not be the exact outcome you want. You have all these things to consider whether or not that is something that you think would be beneficial to you. So like I said, this will take a little bit of self-evaluation. Think about your employment. Do you have a stable employer right now? Do you have kind of like a spotty history of employment where you haven't stayed at jobs long? How will this look to judges? If you have any pending or past criminal charges, these will absolutely be considered by the courts. So you may want to get things resolved. You may also want to get things expunged from your record before filing. These are other things that legal aid can assist with. You'll want to think about your driver's license. Do you have a valid driver's license? Can you transport your children? Can you make yourself available for exchanges? You'll also want to consider your living situation, and not just, the type of housing, how many rooms you have, if you're able to give your children their own individual rooms or a room for themselves, but you'll also want to think about the location. The judges are going to consider the location of your home and if it's in a safe area. Again, we talked about your mental health and your mental stability now. If you've had mental health issues in the past. This isn't necessarily detrimental. What the court wants to know is how you're taking care of your mental health now. Are you in therapy? Are you taking any medication? How are you treating your mental health today so that it won't be a problem for your child? The courts are also going to look at prior court orders. If there was a domestic violence protective order ordered against either party, these will come into consideration. And especially if there was a temporary custody order through a domestic violence protective order, whether or not that worked out, that is going to be taken into consideration as well. And then lastly, you'll want to consider, am I filing to get custody, or am I filing to just get some kind of visitation? When it comes to having a lawyer, it is not necessary for you to have a lawyer in custody cases. However, you do want to ask yourself some questions when making that determination. Some questions that are good to ask yourself is whether or not the other parent is going to be cooperative or if they're going to fight you. If you anticipate that it's going to be a very contentious court action, you may want to talk to a lawyer. You want to also ask yourself, is the other parent likely to get a lawyer? Because if they are, that is another reason that you may want to at least confer with an attorney. And if the other party does get a lawyer, will you be able to get one? These are all questions that you'll want to ask yourself. And like I said, the more likely a case seems to be contentious or to have a lawyer on the other side whose job is to handle these cases, it may be a good idea to, at the very least, speak with an attorney. So like we said, you should get a lawyer if your case is contested and the other side has an attorney, or after reading the entire packet, which there is a custody packet available, you feel like you need the help filing for custody. These are all reasons you would want to talk to an attorney. So there is a little roadmap that goes along with filing for custody. The first step is to, of course, complete your forms. Then the next step will be to file the forms with the clerk of court. The third step is to serve the defendant, which means the defendant is receiving a copy of the court filing and all the paperwork that goes with it. Once the defendant has been served, the case will move on to mediation and court, and we're going to go over each of these. All right, so if you've determined that you feel like you are ready to file for custody, now is the time we're going to talk about all that fun paperwork. And there is a lot of it. So there are about 6 different pieces of paper or documents that you'll need to file. But keep in mind that different counties have different rules and requirements. So you may need to have a different form than we are going over today. But I'll talk about that more specifically as we go through. The paperwork, the first page is going to be your civil summons. The next one is going to be your complaint for custody or visitation. This is going to be where the majority of your case comes in. A lot of the information is going to be in the complaint, and so you'll want to focus most of your time on filling this out. There is also a domestic civil action cover sheet, which, as I mentioned before, some counties have different versions of this paperwork. So you'll want to check in with the clerk of court in whichever county you're planning to file on or file in, and make sure that you get the accurate paperwork. But this cover sheet is basically just boxes that you check to indicate what you're filing. There is a Service Members Civil Relief Act declaration, which involves whether or not the other party is a service member, if they are in the military. The 5th one is an affidavit as to the status of minor child. So for each child that you are filing for custody action, you will need to write up an affidavit, which includes information about where they have lived and where they were born. And then number 6 is an optional form, a petition to proceed as indigent. There is a filing fee and a fee for having the sheriff serve the defendant. If you cannot afford this, you would fill out this petition to proceed as indigent to have those fees waived. There are packets available online, so you can actually fill your paperwork out on a computer or laptop. Otherwise, you would want to get a physical copy of all the paperwork and write it in black or blue ink. When you go to court, you want to make sure you have the original one that you filled out and 2 copies of each form. So you're ultimately going to have 3 total copies of the forms. Some counties, like I said, may require additional forms or different forms than another county. So you'll want to speak with those clerks to make sure that you're filing the right thing. And you can also visit the North Carolina Courts website to get these forms online. Like I said, you can get them online. This is what that page will look like. And you can actually type in certain words to search it, or if you know the form number somehow, you can type it in that way, but it should pop up with whatever you're typing in, and you can download it from their website and fill it in on a computer. As I was talking about, if you do not feel that you can afford the filing fee, you can use the form called Petition to Proceed as Indigent to request a waiver. The form number is right up there. So if you were to use that website, that's the form number you would type in, AOC-G-106. If you do receive food stamps, TANF, or SSI, this is something that you would want to indicate on the form, as it gives you a right to have that waived. Otherwise, the clerk has to decide with their discretion whether or not they're going to waive the fee for you. So be prepared to prove your case to the clerk if you don't receive legal services or any of those benefits. You might have to explain to the clerk why you are applying as indigent, why you think you can't afford this. It is very, very, very important that you do not lie when you're giving this information, because you could be held in contempt of court for giving false information. The form does have to be signed and dated in front of a notary. So that means that someone has to witness you signing it, and you do have to pay for a notary. So make sure you do not sign it until you're before that notary. There are 2 different forms for this petition. There is a civil and a criminal form to proceed as indigent. For these purposes, we are using the civil form. And this is what that looks like. So whichever county you are going to be filing in, that's where you'll want to write it right underneath where it says State of North Carolina. You obviously won't have a file number yet, so you don't have to fill that part in. It will be in district court, and then you'll want to check the first box, the first box that you see, petition to assert claims, which is where you're saying that you are a party that cannot afford to pay the fees for this claim. And so again, if you do get any of those benefits, you can also check that as well. And if you are getting any representation by legal services organizations such as Legal Aid, you can include that as well. Like I said, if that does not apply to you, you would check the box that says it doesn't apply to you, and you may have to explain to the clerk why you are filling out this form and why you believe that you cannot afford the fees. It does cost about $180 to file. The initial filing fee for child custody is $150, and then you can pay $30 for the sheriff's office to serve the defendant. Okay, so back to the top of what we first started talking about, the civil summons is going to be the first form that you fill out. And this form, with that form number right there, AOC-CV-100, is used to serve the defendant. So under the state of North Carolina, like I said on the previous one, you can see where you write in your county name, you check the box for district court, you will write in your name and your address as the plaintiff, since you'll be the one filing. You are to write the defendant's name. So this is going to be the other parent that you're filing against. You'll write their information in defendant. And there's going to be another box that says to each of the defendants below. And you'll again write his or her name, their name in and their address. There is another box that will say name and address of plaintiff's attorney, and if none, address of plaintiff. This is where you're going to write in your information and your address. Again, we'll want to have the original and 3 photocopies here. There are going to be 2 yellow pieces of paper and 2 white pieces of paper. If there is no yellow paper, you can write for service on 1 copy. The yellow ones are going to be for serving the defendant. The original is for the clerk to keep, and then the white copy is for you to keep. And then you might want to keep an extra yellow copy for the return of service from the sheriff if you are serving by the sheriff. So that's 4 pieces of this paper, 2 of them yellow, 2 of them white. Again, if you can't find any yellow paper, you'll just want to make sure you write for service on the ones that are supposed to be yellow. Yellow are for the service purposes. The original goes to the clerk. A white copy goes to you. And let's look at that form. So the top of it looks very similar to the indigency form that we looked at in terms of the county information and the box for district or superior court. Like we said, this is district court. The next piece on there is your name, since you're the plaintiff, your address, city, state, and zip. Right in here where it says name of defendants, you just write the name of the defendant. You don't write their address quite yet. And then below that, however, it says name and address of defendant 1. That's where you'll write in the name and address of that person. If there happens to be another defendant, you'll include their information and address in the second box. As we also mentioned, right down here, it does say the name and address of plaintiff's attorney or address of plaintiff. Again, you'll write in your name and information if you are filing on your own. Okay, so the second form that you're going to be filling out, and like I said, is going to be one of the more important ones because it's including the information, is the complaint. There is a sample of the complaint in the pro se packet that Legal Aid provides. It is designed to be very self-explanatory. It shows very clearly what information you're supposed to be putting. So it's clear what you write. And if you don't know if you're supposed to write something, don't fill it out unless you're sure that it applies to you. There shouldn't be any blank spaces, but if you're not sure, that's something that you could double check with the clerks or an attorney. This is one form that does have to be notarized, so that means you have to sign it in front of a notary. So do not sign this form until you are before a notary. They have to witness you signing this form. With this one, we talked about having the 3 photocopies. I know the civil summons, we had to have 4, but this one, there's only going to be 3. So you'll have your original, and then you'll make the 2 photocopies. The original goes with the clerk, and the photocopy is 1 for you, 1 for the plaintiff, or 1 for the defendant, sorry. And again, you'll fill in your county, your name as plaintiff, the defendant or defendant's names, and you will You will fill out the county where you live. You will have to fill out the county and state where the defendant lives. If it's the same as you, that's totally fine. You'll still have to fill it out for them. If it's a county and in a different county in North Carolina, that's fine. But if it's a different county in another state, you want to make sure that you find the exact county that they're living in. You want to check the box that explains your relationship with the defendant. And there are 3 options for married but living separate and apart, divorced, or never being married. So if you guys never got married, obviously you would check the box that says you've never been married, and then depending on your marital status, you would either check separated or divorced. The next box that you're going to fill out is the full names of your children, the ones that you are filing custody for who need to be minors, and you are going to include their current age and date of birth. The fifth item that you're going to be filling out is where each child has lived for the past 5 years, and that is going to include their address, the name of the individuals that the children lived with. So if it was both of you, the two parties, you would write both of yours, and then you'll also have to write the current address of whoever those people were. So let's say the child lived with you and one of your parents, you'll have to write that and the current address of your parent, since they were someone that the child lived with at one point. You'll have to check any applicable boxes that will talk about other litigations or lawsuits. So there are a couple of boxes that say that you have participated in any litigation that involves that child elsewhere, or if you know about any lawsuits that happened elsewhere. So if custody was ever filed in another state, or there were ever any other custody orders from another state, this is needed to be indicated in the complaint. And you'll have to include the name of the court, the case number, and the date of the decision. If you don't have that information, you need to try very hard to find it and include it in this complaint. Number 6 then is going to be about if you are asking for custody or visitation. And we're going to look at this complaint more specifically, but this box will ask you if you are requesting custody or visitation. So like we talked about, custody is one thing, the visitation is the secondary parent. Number 7, you just kind of leave as is. It says that the parties have been unable to agree on a custody and visitation schedule with the children. So this is assuming that you guys tried to work it out outside of court, and since you couldn't, this is where you are now. So that is already on there. You don't have to fill anything out with that. Number 8 is going to have a couple of different boxes, and you are going to choose which is appropriate for your situation. So number 8 will be saying the court has jurisdiction to hear the case because the children either have lived in North Carolina for the past 6 months, or the child is less than 6 months but has lived here in North Carolina. So depending on the age of your children and what is applicable to you, you'll want to choose whether or not they've lived here for 6 months or lived here for the majority of their life. Then the last part on there is called the prayer for relief, and it is stating what you are requesting. There are 2 different boxes here as well. One is saying that you are requesting custody, and one is saying that you are requesting visitation. So again, you're just specifying what you're filing for. This, again, is a form that needs to be signed before a notary, so do not sign it until you're before that notary. This will also include your signature, but you also have to print your name, your phone number, and your address. And then the notary is going to fill out the verification form that comes after your signature. So let's go ahead and look at this form. So this is the complaint. I talked about each different number and what you're going to need to fill out. So obviously at the top, we talked about a couple different times. You're going to write in the county where you're filing. You will be writing your name as plaintiff, the other party's name as defendant, and then you will be checking the box for whichever you are requesting. If you are requesting custody of the child or visitation, you will check either of those boxes. Number 1 is asking where you, the plaintiff, live. So you're going to write in your county where you're living. Number 2, where does the defendant live? What county do they live in, and which state is that? Number 3, like we talked about, indicates your relationship status. If you've ever been married but you haven't been divorced yet, you're going to check the first box. If you've been married and you're divorced, there's an actual divorce order, you're going to check that box. If you were never married, you're going to check the box that says you were never married. The next number 4 is going to be where you're going to include the information of the children. I know there's not a lot of room there, so you're going to have to make sure that you write appropriately if you do have a lot of children, but that is where you're going to include every child that you are trying to involve in this custody action. You're going to write their full names, first, middle, last, if they have middle, and their ages and their dates of birth. And then moving on is when you're going to include where they have lived for the last 5 years. And you'll be able to write in their name and information, date of birth, and then write in each address for the last 5 years and the dates. and who they also lived with. So like I said, if they lived with you and a parent, you're going to write your name, your parent's name, your present address, and their present address. And you will do this for each child that you are filing for. As I talked about too, there is a space to indicate whether or not there has been other litigation or other lawsuits that have been in other states involving the children. You'll want to get that information and include it and check those boxes if so. This will also ask you if there is a person who has claimed any physical or claimed custody or visitation rights. So anyone aside from the other party that would need to be included in that has claimed custody, like let's say a relative, a non-parent has filed, or an organization has filed for custody or something along those lines at another point. This is where you'd want to include their information. So, oops, sorry. Okay. And yeah, so it just has that twice because it lets you do it for 2 children. If you have more than 2 children, you'll need to fill it out for each child, as I mentioned, and just get another piece of paper that includes that information. Number 6 is going to be where you're going to indicate whether you're requesting custody or visitation. Once again, number 7, like we talked about, doesn't have to be changed. You don't have to do anything to it. It's just saying you guys haven't been able to agree on anything. Number 8 is saying that the court has jurisdiction to hear the case because of the children living there for 6 months or the majority of their life. You'll have to check the appropriate box. And then lastly, for checking boxes on this complaint form, you're going to want to indicate one more time whether you're requesting temporary and permanent custody or temporary and permanent visitation. And then again, wait to sign this form until you're before a notary, and you'll fill out all the information, the date, your signature, your printed name, your telephone number, your mailing address, city, state, and zip. And then this verification section will be filled out by the notary. You will have to sign the verification in front of the notary, but the aspect that includes the notary information is going to be what they are filling out themselves. Okay, so moving on to the next form, then there is another the affidavit for the status of minor child. So this will be, you'll need to fill out one for each child. It is very similar to the section in the complaint where you are writing out the previous addresses of where the children have lived. And this one does have to be notarized as well. So you'll want to wait on your signature until you're before a notary. Let's go to this form. Like I said, it's very similar to what's already in the complaint in terms of the boxes that you're filling out. You're filling out the address and the time period that the minor child lived within the last 5 years, including the names of the people that child lived with and their present addresses. This one will also have a box that says that you would check if there has been other litigation that you have been involved in. So if there were other custody actions or any other litigation that involved the custody of the child, that's where you're going to check that box. And again, it gives you room to fill out the information of that case, that court action. So when it asks capacity as participant, if you were the plaintiff in that case, you'll say you were the plaintiff. If you were the defendant, you'll say you were the defendant. Again, it's going to ask when it was there was a determination, the date of that. It's going to ask for the case number. It's going to ask for court information and any details. And then again, it's going to ask if you have information about specifically a custody proceeding, and you'll have to include that information as well. One more thing that is similar as the complaint is knowing of a person that has claims to custody, and you'll want to include their information as well. Okay, so the domestic civil action cover sheet is Form AOC-CV-750, and this is one that actually may be different county to county. Again, you're going to be writing the county that you're filing in underneath the state of North Carolina section up at the top. You're writing in yourself as the plaintiff, you're writing in the defendant's name, and you're going to be checking the box that says yes next to where it says summons submitted. And then when it says where it says under domestic civil action cover sheet, you're going to choose that it's the initial filing. Since this is going to be the first filing, the first thing that you are doing to start this case, it will be the initial filing. There is going to be a section that talks about juries being demanded. You are going to select no. We do not have juries for civil cases, so this will always be no. The box that states name and address of plaintiff's attorney, or if none, address of plaintiff, as we went over before, this is where you're going to write your name and address. It'll also ask for your phone number and email address. Under the type of pleading, this is going to be a complaint, and the claims of relief, you are going to be selecting custody and or visitation, whichever is appropriate for what you plan to file. This will be signed and dated at the bottom. It does not have to be notarized, so you can sign it whenever you want. And again, this is one that you'll want 3 copies of. The original goes to the clerk, 1 copy for you, and 1 copy for the defendant. So let's look at this one. All right, at the top, we talked about the county box. You're filling in the county where you're going to file. Then you're going to be writing in your name and address for plaintiff 1. And then you're going to be writing in the name of the defendant. It'll ask if summons submitted. Again, that's going to be yes, because we talked about in the beginning, the civil summons, that's what it's requesting if you're submitting that, and you are. So you are going to check yes. And then if there is another defendant, of course, you would fill in their information as well. Skip to the right side real quick. Under domestic civil action cover sheet, where it says initial filing or subsequent filing, like we said, it's going to be the initial filing because this is the beginning. Right underneath that is where it's asking if you're demanding a jury. We're saying no for that. Right under that is where you're going to include your address and name. You're going to include your phone number, and you're going to include your address or your email address. I know it does say attorney email address. That's fine. You can still just write in yours. All right. And then we're going to skip down to the boxes that say type of pleading and claims for relief. The type of pleading, like we stated, is going to be complaint because you are filing a complaint for custody. So that is going to be the only box you'll check on that side. But then when it comes to claims for relief, you are going to either be checking custody and or visitation, depending on what you are filing for. Okay, custody mediation cover sheet. So this is also something that may be county specific. Some counties may not use them necessarily, so you'll want to double check with the clerk of whatever county you're filing in. This form is specifically going to be used by the mediation office to schedule orientation and mediation session dates. So when you file for custody, what happens after the defendant gets served is you both get scheduled for an orientation. It goes over different information about the custody process and what to expect and gathering different information. And then mediation will be set after that. And we'll talk more specifically about that in the end, but that is what is scheduled first before there would be a hearing scheduled. With this custody mediation cover sheet, then you have to fill in all the relevant information for the county specific form, which could be and likely will be your name, your address, date of birth, phone number, email, and all the same information for the defendant, the person you're filing against as well. It'll likely ask about your relationship status if you were ever married, and if you were married, when that date of marriage was, and your date of separation or divorce. If you weren't married, it may not ask for those dates. And then it will most likely ask for the names, ages, and dates of birth of anyone who has lived with the children at any point, as well as their relationship to you. You'll want to sign and date this form, but it is not required to be notarized. This is an example of a custody mediation sheet. It is for Robeson County. I apologize if I'm saying that wrong. I am not originally from North Carolina, but this is an example of something that you would be filling out. So as you can see up top here, it's going to ask for the plaintiff information. That's all your information, your phone number, email. If you do happen to get an attorney, their information is going to want to be on there. So you'll want to know at that point if you have an attorney or not by the time you file. And then you'll want to include the defendant's information. If you know that they would have an attorney, you could include that as well. As you can see there underneath those boxes, then it asks for the marriage date, or asks if you were ever married or if you were separated. And then it asks about the children specifically, and any persons that the children have lived with and the relationship. At the bottom is where you sign it. Again, it does not have to be notarized, so you can sign that on your own. All right, another form that has to be submitted is the Service Members Civil Relief Act form, which, as we mentioned before briefly, deals with whether or not a party is a service member, is in the military, and is on active duty. Obviously, if military members are deployed, they can't easily come to court. So this is something that the courts are going to want to know. And so you do have to fill out this form with that information. And it does give you a link where you can actually check if the person is an active service member. It can give you that information on whether or not they're deployed or available. If a service member is on active duty, the court may not enter any order until the court appoints an attorney to represent that person. If a party is on active duty, in most instances, the case will be stayed, which basically means it's postponed. You're waiting until a later date. And this just ensures that orders aren't entered against service members who can't appear because of their service member duties. So if you are filing any lawsuit in North Carolina, you want to make sure that you complete and file this affidavit when you file your actions, because it is actually kind of common that things such as divorce are denied because the service member's relief form was not filed. It's very important to be filed. It's very easy to file. The only thing that makes it a little complicated is if that person is actually a service member, but the courts will be able to put everything in place to make sure things work out the way that they're supposed to, and nothing is going to be denied because things were filed improperly or ordered improperly. So this is what that form looks like. We've seen the top so many times where it says what county you're going to be filing in. You'll write that in. You'll write your name and your address, the name and address of the defendant, and then below is where you're going to check the accurate box. So the first one says that you have personal knowledge whether the defendant is in the military service. Next one says they're not in the military service. And the next one is you don't know if they're in the military service or not. The second one says whether or not you've received a copy of a military order that says that they are an active member. Most likely, this is not something that you would have received. If you have, you would obviously indicate that you have. If you have not, you would indicate that. The next box is going to ask whether or not you use that website to determine if that person has used or is in the military, and if they're have any active military service. You'll just indicate whether or not you use that site or not. And number 4, you do want to fill out at least one sentence which can support why you are checking the box that you are checking. So if you know that a person is not in the military because you used to be married to them and they have never been in the military, and you know that they have not joined the military since then, that's what you can write. So you'll check 1B, that indicates they are not in the military. And for number 4, you'll say, I was married to the defendant for 17 years and he was not in the military service the entire time. You just have to indicate why you know that information. And then at the bottom is where, I don't think you actually have to sign the bottom. I think that would be, yeah. It looks like the signature. Oh, wait, no. Yes, you do have to sign the bottom. I apologize. Yeah. So the bottom says you declare that this is true and correct. So you are saying the information I'm putting on this form is true, and you have to sign and print your name and put the date for that as well. Does not have to be notarized. All right. So those are the different forms that you're going to need to file. So once you've got those filled out, like we talked about, you'll want to take the original and your 2 copies, unless it's the civil summons. We talked about having the 4 different copies in the yellow paper. You'll go to the clerk in the county that you have planned to file in. That county should be matching the tops of all of those papers that you filled out. You're going to pay the filing fee, or if you are requesting to be determined as indigent for the case, you'll have that form filled out and work it out there. And whether or not that is approved, you'll find out then and there. If it is approved, you won't have to pay the filing fee. If it is not, you will be required to pay that filing fee. Like we talked about, is $150 to file for custody, and then $30 if you choose to have the sheriff file it. You can ask that the copies of the summons be issued by the clerk and have that sheriff's fee ready. So this just means the clerk is going to issue out the summons to the sheriff, so they will get the paperwork and be able to serve it properly. And with that sheriff's fee, like we talked about, that is typically $30. The clerks are going to file stamp all the copies that they need to, and put a file number. So as we stated before, when we were going through that, there's not a file number filled out because you don't have that until you actually file it. The clerk will give that to you. You'll want to pay attention to what that file number is, because it's going to be used to identify your case. So write it down. Obviously, you'll have a copy of your documents too, so you'll be able to look at it there, but it's going to be important for you to know what that case number is. Okay, when you go to pay, if you are not proceeding as indigent, clerk's offices do not accept personal checks. You have to use cash or money orders. So if you have a bank with regular checks, they're not going to do that. You'll have to take your actual cash or get a money order from a bank or another location that does money orders. Clerks are not lawyers, so they cannot give you legal advice. So sometimes if you ask them certain questions, they're not going to be able to answer them. So that is something to keep in mind too when you're filing, to have all your ducks in a row, so there is no issue when you do go to file. Okay, so I've talked a little bit about serving the defendant, and what this means is giving that person a copy of the paperwork. There are different ways to serve them, but you cannot do it yourself. You yourself cannot walk up to this person, give them the paperwork, and say you've been served. That's not how it works. But there are different ways that you can do it. We talked about the sheriff's office and paying that $30 fee to have the sheriffs do it. That's most likely the easiest way to go about it. You pay the fee, the sheriff will get a copy of all the paperwork that's required, and they themselves will go out and deliver that to the defendant. and there will be a form for return of service is what it's called, that says, yes, this person was given a copy of this paperwork on this day at this time, and that's all you need to prove that that person was served. You can serve through certified mail and through publication as well, but these come with their own sets of issues, and this would be something that I would recommend speaking to an attorney about, because there are additional, as I said, there are additional issues that come along with serving this way. But your case cannot and will not be heard without service. A court does not have jurisdiction over a defendant or another party if they have not been served. So nothing is going to happen until the defendant gets a copy of this paperwork in a proper way. Service by the sheriff, as I mentioned a few times, is $30 per defendant. So if there's more than one person you're filing against, it's going to be $30 each time. Same thing where you cannot use a personal check to pay this. You're going to have cash or a money order, and you're going to have to give that to the sheriff's department in the county where the defendant lives. So if you are filing against someone who lives in a county other than you, you're paying that sheriff's office to serve it. You're not paying the county where you live or the county where you're filing, unless it's actually where the defendant lives as well. You want to make sure that you're giving a file stamped copy of that complaint and the summons to the sheriff. So after you filed it, you've got a case number, you went to the clerk and did that, you have that file stamped and ready to go, you give that to the sheriff. They will, and then the sheriffs will actually notify the courts when service is achieved, or affected is a word they like to use as well. And then they will inform you as well and get things rolling in terms of orientation and mediation. Service by certified mail then is what would happen if the sheriff is unable to serve a defendant. So you gave them a chance, they tried, they're not able to do it. You can serve by certified mail. So how you do that is taking a copy of the civil summons and the complaint to the post office. You are going to send the documents to the defendant's home address. So this address would match whatever you filed and included as their address via certified mail with a return receipt requested. So this means that you're going to have to fill out a certified mail slip and a green return receipt card. So that means that if he receives it, he has to sign that he or they received it. When that green card comes back to you in the mail, you then have to fill out an affidavit of service by certified mail, which is another form, and attach that green card and sign the affidavit in front of a notary. So that's another form. You get that green card back that says that this person was served. You get that other form, you fill it out, you attach the green card to it, then you wait and sign it in front of a notary. Make a copy for yourself, and then make sure you give the original to the clerk, and then that will be the record of service. This is what that form looks like. Similar stuff at the top with the county that you're filing in. At this point, you will have a file number. That's why I said it is important to keep that number in mind and know what it is. So you'll actually write it there. And then, of course, you'll write in your information, your name, their name. You will write in your name, since you are the plaintiff. And then you'll write in the address that you sent it to. And then you will write the day that it was received, which would be indicated on that green piece of paper. And then that green piece of paper is going to be attached to this form, and you get this signed in front of a notary. Okay, then I did mention briefly about the publication aspect of service. That is where you can publish information about the case in a newspaper. But again, that comes with very specific issues, and that is something that I recommend speaking with an attorney about before you would go along those lines. What to expect next, though, after the defendant has been served, for sure, that person has 30 days to answer, to file a response. But that doesn't mean that they're going to. A defendant can do nothing. they can make a motion for an extension of time. So that means they're asking for more than 30 days to file an answer or do what they want to do. Or they can go ahead and file an answer with or without counterclaims. So counterclaims are going to be other claims that the defendant feels is related or necessary to bring, and it's going to be something separate. If there are counterclaims that are other than custody or visitation, we definitely recommend that you consult with a lawyer for this, because it's not just custody anymore. So you're going to want to talk with an attorney about what that means for you and your case. And as discussed before, these cases are then automatically set for mediation. You will both have an orientation, which gives you more information about everything. And after that, it's set for mediation before a mediator, and the court will be able to provide you more instructions about what that will look like. So mediation is the process in which a professionally trained third neutral party helps the parties in this case develop an agreement for the care of their children during and after separation. So this person's goal is to have you and the other party work out custody and visitation amongst yourselves. They want you to come to an agreement on what to do with custody and visitation so that it doesn't have to go before a judge to decide. So this is giving you an informal forum to discuss your parenting issues prior to any kind of trial. So like I said, you're going to have that orientation session, and then that's going to be followed with informal confidential meetings with the mediator. The only documentation that will leave any of these meetings is a parenting agreement if one comes out of that. Otherwise, everything is confidential. This person is not an attorney. They don't represent either party. They are neutral. And like I said, their goal is to help the two of you, or however many there are, work out a custody and visitation schedule. And if you do specifically work out a parenting agreement, which could involve custody and visitation or other specifics, this is something that can be worked out through mediation as well. A standard visitation schedule that does come out of mediation or often from judges is an every other weekend schedule with parents alternating major holidays. Some of those holidays are included there, and then splits between spring break and the summer break. So it's usually one parent will have the primary custody, and then the visitation the other parent gets is every other weekend. When mediation is occurring, the mediator will be suggesting what to consider when making a parenting agreement. So they will be listening and making notes of what everybody's wishes are, what everybody's schedules are, and trying to work out and make suggestions for what would be best for you guys to agree upon. If mediation does fail, however, all is not lost. It's not the end of the road. The next step is to just set the case before a judge to have a hearing. What you're going to do if mediation doesn't work out is you're going to ask the clerk of court, who is in charge of setting those hearings, so the family clerk of court, to give you a hearing date, and then they'll also give you other directions on what to do next. So there is a form for a notice of hearing and form for a civil calendar request. This may or may not be required. That's why it's very important to talk to the clerk and see what you need to do to get that hearing date set. It may be that you do need to file this notice of hearing and civil calendar request, where you are just essentially providing the defendant with notice that, hey, there is going to be a hearing, and then you're making a specific request to set your case on the civil calendar. You do have to serve the defendant with the filed copies of both of those forms. But then once a hearing is actually set, you want to make sure that you keep track of those dates and be on time. It is so, so important to get to court on time, even a little bit before court starts is the best, because the judges are going to take that into consideration. You want to start gathering witnesses who can testify to your ability to care for your child, and any evidence that will support your claims that you're providing the best home for your child prior to the hearing. So these would be people who, have seen you around your child and who can actually testify as to your parenting relationship, your parenting skills. So this is a calendar request / notice of hearing form out of Alamance County. Again, other counties may have different forms, or they may not even require that you fill out this form. So make sure that you're double checking with the clerks in the county that you're filing. But once, if this is something that you're going to fill out, it will look something like this. This may already be filled out because it could be a county-specific form. So just make sure that you look at all the blank boxes and you fill out something if you need to. So you'll know the file number at this point. You can write that in. You know that you're the plaintiff. You know who the defendant is. You won't necessarily know if there's an assigned judge. If you do know, you can check that box. That usually happens after this has been filed. If there is an interpreter needed, that will need to be indicated as well. And then you'll want to fill out the subject matter for the hearing requested is going to be child custody. And for other things, I would just double check with the clerks and ask them what you need to actually fill out. Because there's the part up here that asks for like the date requested and time of hearing and the courtroom. That may be something that you do or don't fill out depending on what the clerks say. But then moving on down, you are going to be requesting a trial. So this is that will be the box that you check is the trial box, not a jury trial. Again, we don't have juries for these civil cases. So you're going to be checking the trial box and double check with the clerks about whether or not you fill out those other boxes. Oops, sorry about that. That indicate what dates would be, because it may be that they are able to schedule it right then and there, or it may be that they need to figure it out later on. So the clerks are going to be able to give you the best information whenever you have questions about county specific forms. And then you are going to indicate on this form whether or not the person has been served. And if you've served the defendant, you're just indicating that there as well. All right, so now we're saying we've gotten through orientation, mediation didn't work. So we're at this position where we've requested a hearing, we've got a court date scheduled, and we're just waiting for the hearing. If you need more time, you can ask for a continuance. There's no guarantee that that will be allowed, but it is something that you have a right to request, and it is up to the judge to determine whether or not they're going to grant that continuance. What you would say if you are present in court is you're making a motion to continue, and you're going to want to give the judge your reasoning for wanting more time. And if it simply is that you need more time to gather witnesses, to collect your evidence, that is a valid reason, and that is something that you can tell the judge. If it works out that you're sick or your child is sick and you can't attend a hearing, you can ask for a continuance by contacting the clerks ahead of time and letting them know, hey, I'm sick, I'm not able to be there, I need a continuance. And those are, again, valid reasons to request a continuance. You just want to make sure that you are contacting the clerks and letting them know you're making that request. If at any point you do decide that you want to stop your claim for custody, you can file a notice of voluntary dismissal. A voluntary dismissal will stop the entire trial. You are dismissing your case, you're taking it off of the docket, you are getting rid of it. It is no longer going to be up for consideration. But what you can do when you file a notice of voluntary dismissal is do so without prejudice, which means that you can refile the case for up to 1 year. It is really a last resort to file a dismissal. This is going to be something where maybe you and the other party were able to reach an outside agreement that wasn't through court, and you're like, hey, I want to give this a shot and see how it works. You can take a dismissal in that case. If you decided, hey, I don't think I'm really ready for this, like I need to get my housing situation better, I need to work on my driver's license, anything that you think that you're just not quite ready, that may be a reason for you to file a dismissal as well. But again, it is a last resort, and that's why we recommend very strongly before you file, taking into consideration whether or not you're ready, so you don't have to resort to taking a dismissal when you've already filed the case. All right, when it comes to preparing for trial, there are a few things that you want to keep in mind. Dress conservatively in a professional attire. There is not a necessarily specific dress code in every county. I do know some counties don't like when men are wearing hats, or they don't have their shirts tucked in. So that is something to consider. If you're wearing something that's really short or shows cleavage, that might be something to reconsider. Just think about what would make you feel more comfortable and professional at the same time. But make sure you're on time as well, because it's not only how you look, it's how you appear. And if you are appearing late, that's not going to look good before the judge. So be on time, show that you're interested in the case and that you are interested in respecting the courts and their time. And make sure you're keeping track of those court dates so you don't miss anything. And plan on getting there ahead of time. Give yourself time to park, give yourself time to get through security. Anything that you need to do beforehand, think about the time that you're going to need to make sure that you have enough time to be there on time. Do not drink alcohol or consume any drugs before or during your trial. This, I cannot emphasize enough. It is very important to the judges whether or not you are sober, and especially whether or not you are actively using while engaged in a trial. If you are the type of person that has anxiety and you do need medications for your anxiety, but you know, hey, my anxiety medication makes me a little bit loopy, that is something that is fine, but we would recommend talking to an attorney about, because the attorneys are there to help. They're there to explain things and to give you the best shot. So if you know that this is something that's going to be an issue, that you can't take medications that you need to manage your symptoms, whatever that may be, talk to an attorney about how to navigate this. You can be required at any time to take a drug test while you are there. The judge can, or if you are up on the stand, the judge can order that a deputy takes you and gives you a drug test right then and there. So you want to make sure that you are on your best behavior and you're taking all of this into consideration. When you are testifying, you want to make sure that you are always telling the truth and maintaining your temper and your composure. You want to be cool, calm, and collected. We understand that may be a contentious battle between you and the other party, and some things may be said that you don't necessarily agree with by the other party, but it is so important for you to always maintain your temper. No yelling at the judge, no yelling at the other party, no cursing unless you are, repeating like the defendant's language for purposes of evidence. There's no reason to be using curse words in a courtroom. You do not need to yell or raise your voice. If you find yourself, getting a little overworked or getting upset, you can take time for yourself to calm down. The most important thing is to calm yourself down and to not let that out. When you are testifying, you can stay calm, speak clearly, and make eye contact with the judge as best as you can. Again, we understand people have anxiety and it may not be that easy to make eye contact with the judge. Something that we recommend doing is looking at the wall right above their head. It's looking close enough at them, but not directly at them that it's intimidating. But you want to make sure that you do speak to the judge and direct your testimony to them. There are no juries again, so you're going to want to focus your attention on the judge and sharing your information with the judge, who is the person that's going to be making the decision in your case. When you're preparing, there are different kinds of things that you can bring to help your case. If you have your children's academic records, and they indicate, good grades while they're in your custody, or, slipping grades while they're in the other party's custody, something along those lines. If there are reports from DSS, if there are teacher reports that discuss any of the parenting issues on either side, doctor's notes, things from my chart, anything that is involved in the parenting and your children's relationship that will help you show the judge why they should decide to do what you are requesting. Those are things that you can bring for the judge to consider. If you have been accused of drug use in the past, if you have any clean drug tests that are recent, that is something that you can also bring to show the judge, hey, I'm doing better. This is not a problem. If you have ever been ordered to be in rehab or to take probation, and you have documentation that you've completed those things, if you've ever had to take a parenting class or an anger management class and you completed those things, those are all things that you can bring for the judge to consider as well. And like we said before, witnesses who can testify to your character. These are going to be people that you can bring as well. You're going to be your first witness and you're going to testify, but that doesn't mean that you can't call other people that can also testify as to your character, your good parenting, things along those lines. But you do have to keep in mind that anyone that does testify will then be subject to the defendant or their attorney's questions. And that's the same for you. Cross-examination is what is allowed from the defendant or the other party for anybody's witnesses. So if the defendant has witnesses, you get to ask them questions as well. But you want to keep that in mind. If you know one of your witnesses is kind of confrontational or has a temper, maybe that's not a good person for you to bring into court, because they may be asked a question by the defendant that they don't like and get upset. And that's going to reflect on you and your case, not as much as just that individual person. So you want to take into consideration whether this person would make a good witness and can also stay calm and collected under this circumstance as well. All right. After the hearing occurs, the judge may make their decision verbally in court right then and there, or they take their time to write out a decision and mail it to you. So you may get information that day on what the order will be, and the judge wants to take time to write it up, or the judge may not give you any information and simply mail it to you. So it will really depend on the judge that you get and how contentious your case is. But once a judge does make a decision, it is called an order, and it is a court order. So that means that you and the other party have to comply with this order as written, regardless of how you feel about it. A violation of this order, a court order, can result in punishment for failure to follow the order. And no one wants that. So if something, even if you don't agree with it, you have to go with the court order. And that is something that we ask you to consider before you file custody as well, because it may be something that you don't like and you want to know, am I going to be okay? And can I handle this? And can I respect a court order if it's not something I want? And if you don't think that you can comply with a court order, if it's not what you want to really consider that, because you can be in trouble for not following a court order. That is called contempt. and it is not ideal. As I stated before, you can still modify orders. So if you aren't happy with an order, there is an option to modify it, but it's not that simple. There does have to be a substantial change in circumstances in order to make a permanent change. If it's just a temporary change where it's going to be for, a fixed period of time, the standard again will be, is this in the best interest of the child? But once a permanent order has been made, if you want to modify that, there must be a substantial change in circumstances. And that again is up for the judge to decide. So if, for example, when you had your initial custody case, if something at issue was that you didn't have a stable job or the judge didn't like the location you were living in, but later on down the line, you got a way better job, you've been there for like a year and you're in a completely different location, this may be the basis for a substantial change in circumstances. This may be the basis for a permanent change to that custody order. So those are things to keep in mind. If you do get an order you don't like, it's not necessarily simple to get that changed. Okay. We do, and let me go back to this slide actually really quick. We do recommend talking to an attorney if you do want to modify your custody order, because it is, like I said, it's not that simple. So talking to a private attorney will be in your best interest if that is something that needs to occur for you down the line, or if you are here today listening and you do have a custody order that's already in place, definitely talk with a private attorney about that and whether that's an applicable route for you at this time. But all right, that is essentially the entire presentation. Legal Aid of North Carolina does have a helpline available. We don't typically handle custody cases. I know there are some cases that are handled, but it is a very limited resource that we do have. But if you have other matters that you think legal aid might be able to help you with, you can contact that number there to get in touch with our central intake unit, or you could visit our website for more information on the services that we provide. In terms of finding other attorneys, there is a North Carolina lawyer referral service. The number is below, and the website is also a place that you can get more information on that. What they do essentially is set you up with an attorney for a 30-minute phone consultation for $50. You can talk with the attorney about your issue, get information, basically just consult with them and get more information, or you can decide that this may be someone that you want to hire. So if you do want to consult with a private attorney, we definitely recommend going this route, if that is something that you feel is necessary or you would like to do when it comes to child custody or any other matter that you would need an attorney in. But with that, like I said, that is all of my information. So I'm happy to answer questions. I don't know if I should stop sharing my screen or not to open the chat.
Oh, the chat is open, Carly. I can go ahead and start that.
Okay.
So now we're going to open it up for questions. For anyone with their hand raised, please be aware that you can't unmute in this forum, and you would need to type your question in the Q&A box on Zoom or the comment section on Facebook. And please remember, we can only answer general questions. So with that being said, our first question is, if you're trying to get legal custody to join the military, how do you make your parent the legal guardian while in training?
That is pretty case specific. I am not sure that I know the correct way to go about that. I would recommend speaking with a private attorney for that specific issue.
Okay. The next question is, how do you get legal custody if living in a different state from your child?
So what you would need to do if your child is not living with you here in North Carolina for 6 months, you cannot file here. So you would ideally file in the state where that child is living.
Okay, so the next question is, how can you file for custody if the non-custodial parent is not trying to be found, meaning that the non-custodial parent doesn't have an active address, a phone number, or any current job available?
Yeah, so it may be the case that you may not need to file for custody depending on your specific circumstances. Again, I would advise speaking with a private attorney about your specific situation to determine whether you even need to file for custody in your situation.
Okay, the next question is there a form that can be filled out when the process has started, but the other parent is refusing access to the child until the judge makes a decision?
So, a temporary custody order or an emergency custody order may be ordered if the judge does find it necessary. So this is there could be something temporarily ordered if the judge finds that appropriate.
Okay, so it looks like the next question is, what is the form number for the complaint?
Oh, let's go back to that. Give me one moment. Okay, I'm not seeing a specific form number in my PowerPoint, so I yeah, I'm not quite sure. I would just recommend if you're going to search it on the website, just searching custody complaint, and ideally that would come up. But yeah, I'm not seeing a specific form number for that one, and I do apologize for that.
Okay, so the next question is, where can you find an affidavit of diligent search form in North Carolina?
An affidavit of diligent search form. I don't know that I've heard of that one myself, but any form that North Carolina has provided will be available on their form website. So the link that I showed before with the forms website, it should be available on there. Also, a lot of forms will be available in the courthouse with the clerks. So you can just go to the clerks in person and ask them to give you a physical copy. Some may be willing to email them to you as well. I would just ask them.
Okay, and so the next question, it looks like this is a two-part. It may be too specific, but I'm still going to put it out here. It's can you file a subpoena using child therapy records without an attorney?
I'm sorry, can you repeat the question?
Yes, it's can you file a subpoena using child therapy records without an attorney?
Um, I guess I would have a follow-up question on what you are trying to subpoena, if you're trying to subpoena like a therapist or the records themselves.
Okay, and the second part of this question was, how likely is it for a 50-50 without a custody agreement to be changed to primary due to a child's emotional and psychological concerns with the other parent?
I can't say for sure. I can't give like a number because it's really going to depend on the specific circumstances and the specific judge and what they think is in the child's best interests.
Okay, one moment. Okay, so the next question is, let's see. What should you do if you received a civil summons for visitations?
A civil summons for visitations, meaning like a follow-up question would be, did this person file a custody action where they're just requesting visitation? Is that the question?
I believe so. It's sort of vague here. It just says, "What should I do when I receive the civil summons for visitations?"
Yes, so if someone filed a custody action and you are the defendant, what I would recommend doing if you haven't already gotten the information about when orientation or mediation is scheduled, you should contact the clerks of court and ask them for information for your specific case. You should have that case number. It should be a part of what you were served with. You can give them that case number and they'll be able to tell you if anything has been scheduled or what your next steps would be.
Okay, the next question is, this is a grandparent that has grandsons living full-time without their parents. Can they file for custody?
That is a case specific question. I am not able to answer that. I would suggest speaking with a private attorney for that.
Okay, the next question here is, what is the form number for cover sheet mediation form? Is that something that can just be searched?
Let me see. Okay, so the mediation cover sheets are county specific, so they wouldn't necessarily have a form number, but there is a part on the website that does list local forms and rules. So I would recommend going to the local forms one and searching custody mediation and seeing if something comes up for the county that you want to file in. Otherwise, contacting the clerks of court in that county to ask if there is one for that county.
Okay, so I'm not seeing any additional questions that are general in nature. So with that, I'm going to go ahead and close. So thank you all for joining us, and a special thanks to Carly for presenting. If you would like to review anything we talked about today, we have posted the recording of today's event to our Facebook. It will be immediately available. You can access this with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other listen and learn presentations, such as Social Security, Medicaid, or expunction, you can do so on our website, legalaidnc.org/clinics. Have a great day, everyone.